The Alternative Dig Talk. Real issues, real talk.
They might just be cohabiting, isn't it? It is not allowed.
That's not my Lord, yeah, I also wanted to refer to the nature of work that treaties do. What should take into consideration. I've been hearing my friends, senior friends, arguing that the treaties are capable and they will abide by the conditions and everything. But you see, when you talk about that, then you must prove. And how do you prove that? You need to bring in the issue of the financial ability of your surety. Without that, you better remain mute. And you simply assume that the surety will be able to indemnify court in case the applicant absconds.
Basically, you're saying that the applicant's counsel
overseers.
We're just talking from the back.
Exactly.
Yes, without substantiating the so-called employment and capability to indemnify
in the case of anything. And besides, my lady, if you're careful, apart from and say yes, surety number one is a head teacher. This is his appointment, yes, or AD.
Appointment letter.
This is a person who is the managing director of a particular company. This is the company and this is his identity card. We put them on notice. And in matters of bail application,
you put them on notice
yes.
This morning.
Yes.
So they should have sought for
yes.
an adjournment.
Exactly.
Okay.
My lady.
That was according to your paragraph 5.
Yes, my lady.
Right.
And none of the sureties are actually grouped so. The other thing, my lady, we want to submit, as I said, today is not a day for over-submitting. Is the fact that some of the sureties are really, even without other proof, you will see that they are, for example, okay. No.
They are lightweight.
My lord, you consider that. You consider that about sureties in your ruling.
I don't know what you are telling me. I don't understand.
I had some students, some farmers.
You are talking with farmers.
My lord, yes.
Oh, you meant pizza. So you are on the relatives that can stand place when you are present. The court should not consider them substantial.
My lord, court can look at that. Court can.
What are you advising me to do?
My lord, yes.
I'm just trying to imagine those people who don't have heavyweight sureties in terms of money, big jobs, member of parliament, former member of parliament, secretary FTC. That all you have is your mother from Mulya, who grows cabbage, tomato, and borrowed money to come to court, the High Court and come back. That person who is struck with poverty should never ever get bail in any court under the guise of substantial.
My lord, I have not submitted like that.
I am trying to fix the gap.
That was never my submission, my lord. But I just submit that you look at the sureties presented to this court.
Yes.
My lady, my senior colleague submitted on the seriousness of the offense as being one of the issues that State Rate want to object to the debt application.
Yes.
Whereas I agree with him, there's not a ground. It's not a ground to curtail the rights of the applicant. It is also a ground that courts look at to grant or not to grant the debt application. You cannot
What
overlook.
about seriousness of the offense to the court? You are not guiding.
I didn't want to go into it. But I just thought how. Because, my lord, misdemeanors shouldn't be, the conditions under matter of misdemeanors cannot be the same in, yeah, this is what I'm trying to bring out.
Has been used as a ground or an excuse to keep people beyond the 48-hour who have already been arrested. And then the inquiries in one of the cases that I recently decided on a trial within a trial, the person was in custody for over 6 hours. Recharging time. So when will inquiries be completed on this particular?
My lord, I may not be specific. I may not commit the office of the DPP because this matter involves two states.
How long has the Africans been on the market?
Close to 2 months. No, I am not a party.
Can you ask your file?
I did come with a fight.
From 29 Yeah.
Yeah, so it can be about 3 months. No, it is not very comfortable. I was not assertive.
Can you please stop here?
I was not recorded. I hope my lord am protected.
You are saying?
Yeah, that I may not commit the office of the DPP in respect to when the inquiries in this matter will be complete, because this matter involves two states. And it's not the procedure is a bit complex.
What is complete? Kenya here.
Yes, my entity is a sovereign entity, my lord. It's a sovereign entity, my lord. So sometimes it's not as easy as you may think to get information. So that's what I'm talking about.
So,
My lord, it is not easy to get all the information.
I can assure you that Kenya is a very cooperative state. Kenya, Tanzania, and Uganda, the original members of the community, have very good working relationships. As far as judicial cooperation is concerned, I don't know political things, but judicial cooperation, we have benefited from the collegiality among the stakeholders. That we don't go to
I will not say within the 2 months. That's what I'm trying to say. They may be cooperative.
So you are not, you don't,
Exactly.
okay, because of the transnational nature of the case.
Exactly.
All right. Noted.
My lady, it is a submission that if this court is inclined to grant this application,
Yes.
of course, which is the question of this court, we pray for stringent
Such as.
terms. Such as cash bail, not moving out of the country without consent of this court, Also reporting to the High Court, ICD division. ICD division. I did have sat this morning.
And you are unwell.
Exactly. So it is understandable.
Exactly. So that requires a grand reset countrywide, my lord, and can't be visited on the applicants.
The issue of employment.
The issue
The surety says that they teach or that they own a company.
My lord, I was looking at the guidelines, the practice guidelines,
Yes.
the constitution guidelines for courts of judicature, practice direction 2022, particularly regulation 15, determining the suitability of a surety.
Yes.
When considering the suitability of a surety, court shall take into account the following factors: the age of the surety, work and residence address of the surety, character and antecedents of the surety, relationship to the accused person. That is all, my lord.
It's a guideline.
It's a guideline, yes.
And when the stakes are high, usually the court moves higher in terms of requirements. And I have a case that I just dealt with the other day, where I was given more than I ever needed. Although Chief State Attorney still got up to challenge me. But there was enough documentation supporting almost everything. And that standard is what we should, generally speaking, when we make these applications, stick to.
My lord, yeah.
Especially if it is possible.
I appreciate all that, my lord, but the point here is,
if someone is a teacher, someone was an LC1 here. In that case, there was an LC1 coming from Cologne. And even because submission was that, what can we even know that this man is an LC? Is this even an LC? Then he quickly checked his pocket and came out with evidence that is actually the LC1 of that cell in Cologne. You see that nature of the fairness. But you proceed. I don't want us to. I was just notifying you on that.
my lord,
We are overstayed.
yeah, my lord,
And they have stood. Although they are the most fit people now, the people who are having problems are us who are sitting. Yes.
yeah, the fact that actually we have produced witnesses, my lord,
Yes. Surety.
sureties, is enough to demonstrate the importance and the gravity we attach to this, my lord. Because, my lord, even within the jurisdiction of this, with the discretion of this honorable court, you are seized with wide powers, discretionary powers, to grant bail with or without sureties. But we are making it a point that we have to produce sureties. And now on the substantiality of the sureties, my lord.
Why the courts insist on sureties is because we need a fallback position when people become stuck. And we have had cases where we cannot proceed, and yet someone was released. And when you look at this,
One, the permanent place of our court, his understanding the state is that it should be a permanent house. That's the way we understood here.
yeah, no,
Ownership of a
he
permanent house.
explained it, that either you own it, or if you're a tenant, you produce an announcement,
Our
or
contention,
receipts of payment of rent.
our contention, my lord, once there is a communication from the LCs recognizing and acknowledging that this person resides within our area of jurisdiction, and it has not been rebutted, we invite this honorable court to treat that as sufficient evidence, my lord. Related to that, my lord, some of the sureties have proved that they
Yes.
have brought evidence from their places of origin
Yes.
Not necessarily in Kampala or Wakiso here,
Yes.
but from as far as Peche, Kanungu, wherever.
Yes.
They have come from as far as those areas with that kind of evidence. These are their places of birth. That's where they were
Can
born.
you also respond to council's submission about the distance between the parties, the sureties and the applicants, and the first and second surety as far as their residences or homes are concerned? He thinks that because of that, they will not be capable of fulfilling their duties as sureties.
My Lord, the phrase he used, the level of control. The duty of a surety is not to control the accused person, the movements, to control the movements of the accused persons. I think that would again be far-fetched to say that you are maintaining 24/7 surveillance about the movements of the accused person. That would be far-fetched. It's about reminding the accused person to return to court, ensuring that actually the accused person complies with the conditions, and that can be done even if you are not within the vicinity, within the proximity.
Yes.
And my Lord, in a digital world where we are now, I think matters have been simplified. The communication is very easy. You can always be in touch with anyone. And I've seen, my Lord, right now, court here can even conduct proceedings digitally. It can be done here electronically. So why not the accused person is also conducting business electronically? If court can conduct its business here electronically, this can also happen. So my Lord, our submission is that that would be an onerous condition if it was imposed, that they have to be within the same locality. Yes, my Lord, on the question of inquiries, the possibility of interfering with witnesses.
It was not substantial.
Now, the evidence. There is one element, my Lord, they talked about in affidavit here in paragraph, which he submitted on paragraph 7. My Lord, the applicant is jointly charged with blah blah with a serious offense with strong evidence against him. This is applicable to all of them. That there is strong evidence against the accused persons and is relating it to incorporate investigations. The two are not concomitant. Most obliged, my Lord. My Lord, on the question of stringent terms, that is the last one. He has invited the court to impose stringent terms. And my Lord, we are humbly seeking for the indulgence of court in this matter to be considered. Looking at the circumstances of this matter, my Lord, where the accused persons were picked from Kenya, brought here, and from the record, from the affirmations, my Lord, they spent close to a week in police custody. They have been on remand for the last 3 months. They have families to take care of, and so on and so forth. My Lord, if again onerous conditions are imposed, like cash bail, which may not necessarily be readily available, it's the reason my Lord, it's the reason we are asking for, we are seeking for your indulgence, my Lord. Exercise your discretion under those circumstances to make it moderate, my Lord. Because, my Lord, if it is in the terms as requested by the state, it may not be, again, in consonance with the capacity for the witnesses to meet the conditions, rather the applicants. So it's our prayer, my Lord, the justice of the case. My Lord, we agree.
What is the punishment? State council. Terrorism.
My Lord, also, they have the charge sheet.
No, I'm asking you.
But she's life in prison.
Life in prison.
My Lord, the first case we cited of Dr. Ekiriza,
Yes.
it was a case of treason and rape, but he was granted non-cash bail. So if it could persuade this honorable court, my Lord, to put all those matters into consideration. And in most of these cases we have cited, even the one of Mumbere, whatnot, the one of Mumbere is life in prison.
What was the bail?
My Lord,
The bond terms.
it was 100, not cash. 100 million.
100 million, not cash.
Not cash.
That's a nice one.
So we pray, my Lord, you be pleased to admit them to bail so that they can regain their freedom and liberties within the purview of the Constitution. We do so pray.
Given on Tuesday by email to counsel for your parties, who should leave their emails behind with our worship, Bibino, the registrar, the magistrate in charge of my chambers. So leave her your email addresses so that you get the full ruling of the court. As for now, I am giving an abridged version which is that the applicants are entitled today to apply for bail, and the court is entitled to either grant or refuse to grant bail to an applicant after considering all the circumstances of the case. In this case, the offense charged of terrorism is bailable, and the court has decided to grant bail to each of the applicants in this case. Don't make my tempers flare. This is not the party headquarters of any party where you do the clapping. Okay? Because here I am not interested in the clapping. Whether you clap or you don't clap, I will still get my salary. So that's why you should not clap. Because the office that I seek in judgment here, my problem will be in heaven if I don't execute it properly. And the Constitution is what binds my decisions. So what are the terms? Each applicant shall execute a cash bond of 2 million shillings. Each surety of the applicant shall execute a non-cash bond of 50 million. Non-cash bond for each surety. I don't know where the applicant's passports and IDs are, but I order that their passports be deposited, those that have passports and travel documents, to this court with the registrar, the deputy registrar of this court, for her custody and safety. None of the applicants shall travel out of the country without the permission of this court through the deputy registrar of this court. So if you want to travel, you come for permission to do so and pick your passport or travel document with the registrar of this court. The registrar of this court shall notify the immigration authorities of this country of this restriction to your travel. I mean, you might choose you might decide to smuggle yourself because Uganda has corners for this. But I hope you don't. she shall notify the Immigration Authority of the order limiting your movement and the conditions. The condition is permission. Permission from the court. Each applicant shall report to the Deputy Registrar once a month. And that calculation of once a month will be made from the date of your release by the registrar. She should tell you and inform you of your next date of reporting to this court. Which shall be notified in your bail bond form. You will report to this court for a maximum of 6 months from this date. Because within 6 months, the state should have prepared committal papers for committal proceedings if they have the evidence, and other arrangements will then be made regarding your reporting. Failure to commit the accused persons for trial within 6 months from this date will result into their automatic release from the terms and conditions of this bail release. And that will mean a release of the sureties as well. And they will be discharged if state fails in 6 months from this date. I don't know mathematics, I would have given the exact date. I saw all that.
Bebaza omulimu ogukoleddwa ttiimu eno gye mulaba ey'abannamateeka ebadde tetuula nga omulabye omulimu tegubadde mwangu. Abantu baffe okuva lwe babakwata ng'ennaku z'omwezi 23 Julayi ne babajja e Nairobi ne babaleeta e Naggalama ne bamalayo kumpi na wiiki namba nga 29 ne babatwala mu kkooti e Nakawa ne babagulako emisango. Okuva olwo na 2 ze tubaddemu okuviira ddala nga 23 Julayi okutuusa olwaleero 2 nga tetutudde babaziza wano babatutte ekitalya babatutte ruzira nga tubadde mu 2 n'okukola ku nteekateeka ez'okulaba nti tufuna bail application. Ekyennyamiza nti n'okutuusa kati state yo tennaleeta bujulizi tebuliibo era tebannaba commuting era n'omulamuzi mulidde mu jaaji mu rulingi akyogeddeko ng'alaga nti naye ebbanga lino lyonna nga temuwozesanga bantu bano era mu rulingi eyo gye twebaza omulamuzi akiraze n'aga nti naye mutakikola mu myezi 6 abantu bano zijja bajjako obukwakulizo. Ekirala twebaza omulamuzi nti musango bail application ebadde mpanvu kuva ku makya ebintu bibadde bingi gafuli mugalabye naye n'asalawo n'agamba nti rulingi kagiwa olwaleero eriditeda n'agiwa olulala. Ekyo kikolwa kibadde kya bwenkanya nnyo kuga nti kasooke atuweerewo ekiragiro kiga nti abantu baffe babawadde bbeeyi okuggyako nti okwakuliza obubiri n'omwaka essente miliyoni 2 kyo kitegeeza twetaaga miliyoni 7 mu 2 abantu 36 si sente ntono ekyo kibanga emitwalo gya $2. So tulina okugenda tugulube nazo akaseera kano kubanga tezibeerawo nti tuzirina ffe situlinga bannaffe bali abali mu state sente beziyitaba nga bakwata mu kintafu kya ggwanga. So tugenda kuddayo twekwanyekwanye tulabe tufuna sente ezo. Ekyokubiri kyekiragiro ekigamba nti passports zirina okubeera deposited wano kakati tugenda kuguluba na state olw'ensonga nti passports ne identity cards ez'abantu bano bajjako nga babakwatidde ekisumu n'okutuusa kati twafuna court order wansi magistrate court eragira nti babaddize property yaabwe n'okutuusa kati bakyagaanye babajjako computer babajjako ebiwandiiko byonna n'okutuusa olwaleero ebitannabaddizibwa. Naye kati nga bwe tufunye ekiragiro ekya court wano katusuubire nti buno bagenda kugonda batuwe passports ezo zijje wano kuba ndoza kyekigenda okutulwisaamu akatonotono ekyokufuna passports ezo okuzijja mu state. Nera nga tubagamba
nti bagondere ebiragiro bya kooti. Bajeemera ekiragiro kya kooti ekya wansi ensooka yabalagira nti batuwe passports ezo n'ID ne bagaana. Babalagira abalwadde baffe babeexamininge batuwe medical reports, naye medical superintendent waabwe mukulu Alex Kakolaki yatuwaddeko makoka Samuel. Kakati nga bwe tufunyeyo ekiragiro ekisingawo ekya kooti ekigamba nti passports ezo zijje wano, katusubire bagenda kigondera mu bwangu ddala. Ndowooza bwe bukwakkulizo bubiri bwokka abantu baffe bafulume. Saakaffe kakunoonya ssente ze tugenda zinoonya mu bwangu tulabe nti zijja, then nga bwe tuba tulinga ne state etuwe passports tulabe nti abantu baffe bavaayo. Basically byebyo bisigadde tukyaba tolinga nabo, katusuubire nti banakomply ne order za kooti.
Just briefly.
The Alternative Dig Talk. Real issues, real talk.